Welcome to the Human AI Alliance podcast. Thank you very much for joining us. Really appreciate it. Today we have Caro Robson, who is joining us from the UK. Thank you very much for coming on to the Human AI Alliance podcast. If you can give us a little bit of a view of your journey into AI, I'd really appreciate it.
Yeah, well, I'd say it wasn't my journey into AI. It was more AI journeyed into me, really, which is not to say I'm a robot or a deep fake. That's not what's going on. Or is it? No, it's really not. I started off in technology over 16 years ago. So AI's just come along in that time, and anyone working in digital, data or tech has had to come to terms with it. And I've got really enthusiastic about it. So I started off with the National Crime Agency here in the UK. Then I was in Afghanistan for 18 months during the conflict, advising on these issues. Then I built compliance programs whilst I lived in the Middle East for two multinationals in aviation and payments. Then I advised the EU Commission in Brussels on all aspects of data, digital, cyber, and of course, AI regulation. Then I was strategy executive for an information regulator. And now I'm a member of a UNEC working party, which is developing the common regulatory arrangements for AI. I'm the UK ambassador for the Global AI Association, and I'm a non-executive director for an ethical AI startup. So yeah, an enthusiast and very much keen on AI in all its forms.
Well, when I started out the podcast, I really wanted to have detailed, high resolution answers to a lot of the kind of the deep AI questions that people are having around AI, and one of them is related to the legislation, so the EU AI Act specifically that is coming down the line. But in order to be able to kind of really start that question, we almost need to start with the definition. So how would you define AI?
That's a really good question. And it got more complicated a few weeks ago when the Commission released its guidance. So to take a step back, the AI Act is a combination of product safety legislation. So anytime someone reading the Act sees a reference to the new legislative framework, the Blue Book or product safety laws, that's what it's talking about. So that's a really separate area of law to the other thing it's doing, which is fundamental rights, which is much more like the GDPR and privacy. So that's the position that the Act is taking on AI. It's kind of like a product, a safety issue but also affects fundamental rights. The way I would define AI, which until a few weeks ago I thought was entirely coming from the Act, is a system that infers outputs from inputs. And when you talk to data scientists and look at the standard technological definition of inference, and I love Jeffrey Erickson from Oracle's definition on this, to infer means to be trained on one set of data and then spot patterns on a different set of data. So that for me is the real key to understanding AI and how it's different to traditional software. You're trained on one set and then you spot patterns on another. And that immediately gets you thinking about your supply chain, your source data, biases, and issues like this. The Commission published guidelines on the 6th of February on the definition of AI. And at paragraph 23, they have specifically said that what I've just said, being trained on one set and operating on another, is incidental. It might happen, but it's not determinative of whether you're AI. However, I think the rest of those guidelines, which are quite complicated, we can dig into them if you like, but I think the examples they give kind of bear out that what I'm saying is a good rule of thumb, because the examples of what's not AI are things that are in-house, are trained on one set of data. So just visualizing data sets, basic linear or quadratic regression of data sets, anything that's making simple predictions on data sets. Rather than have an inexhaustible set of definitions, I think what they're getting at is that difference for me between if you're trained on one set and can spot patterns in a different set, you're more likely to be an AI system. So it's got a bit more complicated, but I think my definition still kind of holds based on the examples that they give.
Yeah, and for me, it was 13 pages, and they really try to get into the nuances of it. But the problem is they've almost made it more complicated in doing so. That was what I lifted from that. I do like your idea around inference, though, is that when it is trained, when an AI is trained on one set of data and is exposed to other types of inputs, it can then at least guess the outputs or assume the outputs or infer the outputs based on whatever other knowledge it is grounded in. Because I think that is, for me, also part of what you're articulating, is that there is knowledge within that AI that you are able to call on using knowledge that you've got, that you ground that AI in. I think that is also quite key, right?
Yeah, I think so. I mean, I'm always nervous about these anthropomorphic terms like knowledge when it comes to systems, because it means that we can overestimate how sophisticated some of these parametric models in particularly are. But it's kind of the best term we've got, so let's roll with it. So that training and learning that is contained within a model can then be used and put to work on a different set of data. I think that's sort of the difference, and completely agree. I think these guidelines aren't very helpful, and they do muddy the waters an awful lot. I'm a bit worried that companies might use them as a way of saying, we're not AI because such and such a paragraph says. I don't think that's the intention, but I think if you stick to that rule of thumb and you look at the guidelines and they talk about basically anything that's new, anything that's complicated, anything that's nuanced, anything that's a bit difficult, that's probably AI. So that rule of thumb of you're trained on something and then you've got the knowledge, the learning, the patterns to spot those in a different set, I think is still a good rule of thumb. So I'm going to stick with it.
Excellent. So as we kind of go into that definition, I think one of the key elements that is coming out, especially since the 2nd of February, within the EU Act, is the concept around AI literacy. And a definition around AI literacy is, again, fundamental to that. So in terms of AI literacy, there is a bit of vagueness because there isn't kind of direction exactly what AI literacy is and how you're supposed to prove that you're actually in compliance to that. So how would you define AI literacy? How, beyond just what is in the text? I think start with that, but then kind of lift out from that how you feel an organization from a micro to an enterprise could actually comply with that requirement.
Yeah, so it's hard to give a really clear definition of AI literacy from what's in, it's actually Article 4 of the Act, and then in Recital 20, which says, well, you've got to have a basic standard of AI literacy, and it then goes on to give some things you've got to take into account and people that you need to include in that. It doesn't really define AI literacy. So for me, again, I kind of work on rules of thumb, because when you're operating at this level of complexity for companies, I think it's helpful. I think I would define AI literacy as the knowledge that people in your organization need to get the best out of AI and to avoid the worst of AI. That's how I would define AI literacy. And so the Act, the recitals talk about you've got to have a reasonable level of knowledge for your employees, for anyone who is using AI on your behalf, kind of as your agent or your contractor, and taking into account anyone on whom the system may be used, which sounds really nefarious, but basically any data subject, we'd call it in privacy, but a person who might be affected by your system, you have to take those into account as well. And so for me, it's about stepping back and thinking, what are the basics that everybody needs to know? What are the details of your own organizational policy? You also have to take into account the context that you're using AI. And then what are the risks and how do we mitigate them? So for me, I would suggest that organizations have a very basic training course for all of their staff about what AI is. Maybe don't use those guidelines as part of it, but what AI is, how to spot it, why it has risks, what its opportunities are. And then think about perhaps more targeted training for your different groups. So obviously lawyers can crack on and look into the Act and the regulatory requirements of many other countries that have these laws. Technical teams might want to learn more about different systems and deployments of AI and ways that they can optimize it. And the board in particular, I think, needs to be brought into this conversation. With algorithmic bias, we've seen a lot of lawsuits. Westpac's a good example, State Farm's another one, where board members have been held personally liable for just algorithms making decisions about their end users and customers that have impacts on them. So boards need to be aware that the technology they're using could have those impacts, and they have to accept risks. They'll be mindful of those risks. So what I'd say is know your audience, make sure that you're tailoring your communications, give basic information about what AI is, what it isn't, how your organization is using it, That involves knowing how your organization is using it. If you've got an AI policy, for example, if you prohibit employees using ChatGPT or Grammarly or something like this on their desktop that isn't corporate approved, make sure that you train on that policy so people are aware of it. And also communicate. I would suggest that it isn't just a black box that's completely unknowable. There are ways we can understand what's going on with AI systems and how they work. So publicly available safety papers, for example, or model notices can give that information. It's not a silver bullet, so know the limitations of your system, but also understand its real benefits and how to get the best out of it whilst mitigating those risks. So that might sound a bit complicated, but basically, take your business sense first and think, what do people need to know to get the best out of this and avoid the worst?
If I have to kind of distill down what you were saying between your definition and the AI literacy, the way that I see it is that you've got the product piece and you've got the fundamental rights piece. So in the product piece, we've got a really good idea of what to do from a business perspective, right? You are developing a product, a service, something, you're taking it to market. And the way that the legislation has been written is that you need to understand how that product is designed. You need to almost do a safety check on your product before you put it into the marketplace, essentially. And you need to know and you need to train your team in order to develop the required safety mechanisms inside your development cycle, inside your aftermarket services. The second piece of that, which is the fundamental rights, that is going to start to come a little bit later for all intents and purposes under the high risk and under the transparency regulation, but that will become clearer over time. Focus on the piece that you can do right now, which is around training your team, getting them up to speed, helping them understand what AI is, how to recognize it. Is that a good summation?
Yeah, I think so. I think with high risk systems, so that's not enforced yet. We've just got prohibited systems is now, or applicable rather. Everything's enforced, but it's applicable. The prohibited systems, so high risk will come in later. For those systems, product safety law is going to start to apply in those principles of conformity assessment, having conformity marks, having checks done. So asking permission, not forgiveness, which is a bit of a different mindset for a lot of organizations. If you don't work in, say, aviation or an engineering company, you might not be used to having those systems in place before you go to market. So it's a bit different. But you're right, having that basic knowledge with your product team, with your legal, your compliance team, having those communicate around who is going to be affected by this, what are the risks around it, and then what are the safety implications, I think is important. And one other thing to say, which I think is a big opportunity with AI literacy, actually, the Act says that it doesn't just apply to your employees or people using it on your behalf. It should be across the supply chain. So AI literacy should extend from providers of systems, that's developers who provide your company, if you're a user, with that system, and also end users and consumers. So I think it's a really good way to get your suppliers and vendors involved, have a conversation around what this system does and how it works. Even if the transparency requirements aren't there or aren't in place yet, have that conversation and bring them in, because you can learn an awful lot as a business about how these technologies are functioning, how to optimize them, and what the risks are. Perhaps using AI literacy as a vehicle to have a conversation throughout the supply chain. So I think that's another big opportunity here from the Act.
Yeah. So just in terms of organizations can face fines right now from the EU AI Act, specifically because of the AI literacy piece is in place. But if you know, how would somebody be able to enforce the AI literacy? Is it enforceable right now? Because it's come into force, but as far as I understand, from a governmental or oversight perspective, there's nothing until August. But as a layperson, as a person on the street, as an employee, you know, is there any recourse that you could take against an organization relating to AI literacy?
So this is where you tell I'm really a lawyer. It depends is the answer. It depends. So you're quite right. Prohibited practices and the AI literacy requirements are now in force and applicable. So the law has been passed and action can be taken against you. The penalties don't come in until August. So right now, you can't be fined up to 7% of group global turnover or 35 million euros, whichever's the higher. But individuals could take legal action against you in a member state for breaching these requirements. How they would do that would depend on the member state. So it depends on the legal system in each country, depends on what rights you have to have a judicial review or to have review of breach of legal obligations, whatever the law of tort or contract allows in that particular country. That law could be used by an individual affected by your systems to hold you to account for not putting this in place. So it really depends on the member state. I think the better argument for this is it's actually really good business practice, especially if you can get your suppliers in the room. It makes sense. You're going to get the best out of AI if people understand it and know how to use it. So I think the AI literacy requirement is a really good vehicle to get that information out there.
Yeah. So I think we've gone quite practical for a moment. So I think let's just take it up a level. We had the AI Action Summit quite recently. There was a lot of political bun fighting and between the different nation states that were there, between the UK, the US. They didn't seem to particularly buy into it. There were a lot of outcomes that came from that. Could you give us your distilled version of what came out of the AI Action Summit?
Yeah, this was really interesting. So it came 9th and 10th of February. So just after the DeepSeek R1 model had been announced. So President Trump has been in the White House for just a couple of weeks. R1 has just been announced. And so that seems to have shaken US confidence in its dominance of the AI market. And then we get what's now called the AI Action Summit. Was the AI Safety Summit's been renamed Action. So there were a lot of expectations that countries would roll back on their big gigafactory projects, but actually the opposite happened. France announced 100 million euros for gigafactories. The EU announced 200 million euros. And significantly, J.D. Vance, the US vice president, gave an excoriating speech arguing that EU regulation stifles innovation and is a huge problem for US tech companies. He didn't name the AI Act. He named the Digital Services Act and a couple of others, but he didn't name the act. But it was really taken as a big criticism of EU regulation, even though actually DeepSeek was innovative because China is such a heavily regulated environment. But that's maybe a different conversation. So the day after the summit, a related directive to the act, the AI Liability Directive, which was going to set out rules on who is responsible when AI malfunctions, that got dropped. It just got dropped instantly. MEPs who were supporting that legislation just 2 days before the summit were then saying, yeah, we couldn't reach agreement, it's gone. Political reports that some members of parliament are actually still working on requirements, but that's been dropped. We've also seen the EU's competitiveness compass, which is its deregulatory ultra competitiveness agenda, come out. Again, it doesn't mention the AI Act. It talks about building gigafactories, but it's looking at a more deregulatory agenda. And we've had from the Commission, their work plan for 2025 has just come out, which includes, and you've got to be a nerd like me and really dig down into the footnotes for this, includes a review of the digital acquis, or acquis, digital acquis, which, if you look in the footnotes, includes the AI Act. So it's something that might be reviewed in future. But for now, these provisions are in force. The rest of the Act is scheduled to come into force, and member states, even though they should have notified in November, are still getting ready their designated authorities to notify the Commission. So it is still in place and it's still happening, but there are headwinds that maybe it's going to be reviewed.
For those different member states in getting their house in order, do you think that they're going to ask for like last minute extensions? Is that possible within the Act? I mean, essentially, is it almost like, because of DeepSeek, because of the change in the political winds, geopolitical winds, that the EU AI Act is starting to kind of lose its momentum? Or do you think it's just a bit of a kind of a lull right now, and it is going to take off because people are seeing it as a value add, especially around the product safety piece? And I think that's probably missing. But yeah, what's your thoughts?
Well, certainly all the product safety legislation will still apply. And the Act, you can see, is kind of underpinned by this net of the new legislative framework and individual product safety laws. So all of that is there regardless of the Act itself. Member states under the Act can't ask for an extension from the Commission, But what usually happens is if a member state is seen not to have implemented a regulation or a directive, there's a quite nerdy legal procedure called infraction proceedings. And what the EU Commission can do is take the member state to court and infract them and say that they've not complied with the regulation. I think that's unlikely to happen, although the Future of Life Institute has done some brilliant work on how many member states have actually designated the different authorities that you have to have under the Act. You have to have a market surveillance one for the product safety side and someone for fundamental rights for the human rights side. Only one has designated both. Some have designated one and not the other, but only one has designated both. So there is still work to do. Member states don't have to notify the Commission until August of the human resources and the headcount, but it's slightly slow, shall we say, uptake on this. But I think we'll see the impacts of the Act and whether the EU AI sector really starts to flourish and develop, how harshly it's enforced. We'll see how it actually takes off, I think, to see where it goes.
So you've lived through the GDPR process. How long did it take for the member states to actually fall in line and get their ducks in a row in terms of those different departments and ready to actually start implementing? Do you think they're going to get to the lastminute.com and throw some names over the fence and say that's who it is for now and we'll update it later? Or, I know it's from a legal perspective you can't do it like that, but behind the scenes it might be as kind of veneer as that.
Yeah, well, the GDPR was slightly different because one, it was on the back of the directive, the data protection directive. So member states already had supervisory authorities in place. Everyone had to put that in place under the 95 directive. And the GDPR took much longer to negotiate. So it started off, I think it was 2012 when things started there, and it wasn't passed until 2016 and enforced 2 years later. So the AI Act, for all its faults and failings, has been lightning quick in terms of how it's been drafted and put together and passed. So it's slightly unprecedented in that regard. But it is drawing upon those two different areas of law. Product safety. So most countries have a national standards authority, have compliance assessment and market surveillance authorities and conformity assessment bodies, and they've got data protection authorities. What's super interesting is actually countries haven't just said, yeah, it's that one. Most have designated multiple agencies. So most have designated kind of between 7 and 10 different agencies just to deal with the fundamental rights piece, and a handful to deal with the market surveillance piece, which personally I find really interesting, because if you were to do the lastminute.com, you can tell I was the kid who was always late with her homework. You would just say, yeah, it's my market surveillance authority, done. But actually they're designating multiple authorities. And that's super interesting because the Act was meant to be this big omnibus legislation that absolutely clarified everything. And the UK, which has, of course, left the EU, its approach to having multiple regulators was seen as a bit mad. And now that's what we're seeing happen in member states. They're having multiple regulators responsible for the Act. So enforcement's going to be interesting, I think.
Yeah, that is going to be quite interesting. Okay, staying within the geopolitical world, we've got the EU AI Act. For now, it is coming into, well, it is enforced, and we've got the first pieces coming into effect. But from a global perspective, right? So if you're outside of the EU, how is this going to affect you? I think that's part of the first part of the question. So if you're in the US and you're selling services in, or you're in Australia, or whatever the case may be, or South Africa, and you're selling technology or capability, AI capability into the EU, how are you affected by this? That's the first piece. And then the second piece is there any other kind of complementary laws, like in the case of privacy, where multiple countries aligning to GDPR? Is that happening at the moment on a global level?
So I'll take the second of those first. At the global level, we've got a number of UN General Assembly resolutions. The general one on AI safety, one that was proposed by China, one that was proposed by the US, and both supported each other's resolutions, bizarrely, last year. Surprising given what's happening in the markets. So we've got the UN work and common regulatory arrangements, which is where countries can sign up to a framework for what their laws should look like. We've also got the OECD doing work in this area. We've got various principles coming out of standards bodies and standards agencies, the international forums for the internet, the information society. There's lots of different work going on to bring countries together and try to establish frameworks around this. There's also a lot of national legislation going on, even in the US. So President Biden's executive order was revoked and rescinded by President Trump, but many states have AI laws. 3 have omnibus laws, Utah, Colorado, and California, but most have some kind of legislation impacting AI. Around the world, you've got AI business guidelines. Many have AI acts or AI principles for the likes of Australia. Canada has a draft bill. So there is a lot of legislation happening and a lot of coordination going on to try to get some international principles. So that's kind of what's happening in other countries. In terms of how individual organizations are affected by the EU AI Act, to be boring, it comes back to definitions. If you are a provider, a deployer, an importer, or whatever of an AI system, particularly if you're a provider, I would say this applies to. So if you're a developer and you put your product on the market or make it available for somebody in the EU to use, whether that's an individual, whether that is a company, whether that is for payment or whether it's for free, the act applies to you and you are expected to comply from the point it's put on the market with transparency, AI literacy, the different tiers of risk and the classifications of what you have to do for each different type of system. All of that applies to you if you make a system available on the EU market. So the likes of ChatGPT would be put on the market. So OpenAI would be a provider because they are providing that and making it available in the EU. There is a question over what you have to do before you put things on the market. Product safety legislation normally requires a lot of work to be done before you actually launch the product. The Act technically doesn't apply to that activity, but there are some provisions that say, well, you should really have done this before it goes to market, and it's on the importer or the distributor to check that you've done it, or the deployer to check your paperwork. So really any company around the world, if you are putting an AI system on the EU market and making it available, this Act would apply to you and you would have to adhere to its principles. I think the question then comes about enforcement. And I wonder if we'll see something similar to the GDPR, where it's really the big tech players that get targeted for activity, as we've seen with the likes of OpenAI and now DeepSeek with privacy authorities.
Couple questions that have come in. I see Eva and Christopher have come through. So Christopher asked a question: how can our business determine if it needs an AI policy?
I think it's a good idea to have an AI policy for all organizations, but particularly if you are using AI or you suspect your employees might be using AI. So for example, ChatGPT on the desktop, it's a good idea to have an AI policy. And the reason for that is twofold. One, it helps you mitigate your risks and make sure that people understand the risks that are involved in using AI, how serious it is, and that you've got some recourse if that doesn't happen. And two, it helps you educate your employees and everyone in your organization around AI, its uses, but also its benefits and its potential. So I would suggest anyone has an AI policy. How complicated that needs to be and how nuanced it needs to be will depend on the size of your organization and what you're doing with AI. But I would recommend that you do have something, even if it's just drawing upon your existing cybersecurity data protection policies.
Yeah. And then Eve asked, having vendors confirm their AI literacy sounds similar to a double material goals for CSRD. I'm not quite sure what that is, but I think what we're talking about is third-party risk management and basically making sure that your vendors have policies, procedures, and standards. So
yeah. So this is the corporate, I believe it's the Corporate Sustainability Reporting Directive that's been referred to, the double materiality under that.
Okay.
That's another interesting one in terms of the geopolitical headwinds of what's going on with the deregulation agenda, because the CSRD has just started to apply now to organizations that are going to have to start reporting that information. And it might be one that's up for review under the competitiveness compass, actually. But it is very similar to that. It is about making sure your whole supply chain is compliant, and that both is a requirement upon you if you're a deployer or user of systems, but also it's an opportunity for you because it means that you can go back to your vendors and ask, how does this work? How is this functioning? How is it integrating with my systems? How is it using my data? You need to give me this information because I have obligations and so do you. So you're right, it is quite similar, but it's a good opportunity, I think, for businesses to find out how their vendors are operating the AI systems they use.
Final question. So I want you to pretend for a second, and this is quite a quick fire one. So pretend you're walking into a mid-sized organization, 150 people or so, and the CEO has basically tasked you to come in and basically do a super fire quick check on whether or not they comply with the EU AI Act. What would be the core elements that you would want to kind of pick out and go, okay, cool, this organization actually understands it's a product piece of legislation and it's a fundamental rights piece of legislation. What would be the artifacts that you would want to know that they've actually understood it and implemented it according to the AI literacy and according to the requirements?
So as a regulator or someone coming in, you'd be looking for, have you mapped out your systems? So have you got some kind of record of data processing or systems records? The transparency requirements under the Act we won't dig into, but having a record of what systems you're using are important. So do you understand when you're using AI? Do you know what data it's using? Do you understand who of your end customers are accessing and using that AI? Have you documented your risk tolerance for AI? So your organizational understanding of when to use it? And do you have, to the previous question, do you have an AI policy around this that you're training people on, training not just for AI literacy in general, hugely important for implementing a policy? You've got a training program. Those are the kind of documents that I'd be looking to see, those artifacts to show that, yes, we've thought about this, taken it seriously, educated our employees, our colleagues, and are making sure that we're not just complying with the Act, but we're getting the best out of AI. So I think it's good business sense as well.
That was amazing. I'm going to end on that. Caro, thank you very much for your time. I really, really appreciate it. If you want to learn more about the Human AI Alliance, please like and share the video. Please look out at the book. And again, please keep the conversation going by posting questions or suggesting hosts that we could go deep into AI questions. Thank you very much. Thank you, Caro.
Thanks so much, everyone. Thank you.